Hello, I am Lanuja. For this assignment, I'm gonna answer almost 9 questions with the supporting references. Mm, yeah, I satisfied with the requirements of each of the questions references, but moreover, some of them I couldn't get the live evidence, so I just talk about something about that. But otherwise, the minimum reference number of references will satisfied through that, even if I didn't give that links are it's a addition. So okay, let's start with what we mean by reasonable expectation of privacy. So this idea, so move to the question number 1. So this idea is the foundation for everything. So we are talking about in this course. So it's what decides when the government, police, or even employers can legally look into someone's private information. So in Canada, the protection comes straight from this Section 8, um, uh, Canadian Charter of Rights and Freedoms. So here is the link. So this is the law. It protects people from their private information. So it basically says that everyone has the right to be secure against unreasonable search and seizure. So in simple terms, it means that before police can go through your phone or the email or even our house, so they usually need a warrant from a judge. So the next one is a really big case that shaped with this idea in Canada was R.V. Spencer. So here is the court judgment. So in that case, the Supreme Court said that even something like subscriber information, so like the name and the IP address, which is our internet provider has, or everything's are private. So police can't just ask our ISP for the details, so without any warrant. And another case, I couldn't get the live link, so I just talk about that too also here. So another case also RV test link. So which one is made it clear that privacy extends even to things like thermal imaging, so from outside our house. So technology doesn't give police a free pass. So if we jump over the United States, their version of Section 8 is called Fourth Amendment. And so here I attach with the famous case of Cats V. So here's the link. So here's that. So which is happened in 1967. So it's where the court said the Fourth Amendment protects people, not places. So that's such a powerful line. So it means what matters is not where you are and whether you had a personal expectation of privacy. So, and moreover, the 2018, so this is the another case. So, which is also updated that idea. So for the smartphone era, so now everyone has a smartphone. So there's a lots of pictures, or we can trace everything and the videos and the it's more smarter. So the court ruled that police need a warrant to access our cell phone, like location data, because it basically reveals a whole life story, where we are, where we went, and everything, whole the life story. So they need a warrant for to check our phone. And When I go over the United Kingdom, so they have the Human Rights Acts like 1998. So I couldn't get the tagline here. So, but it makes an article of European Convention of Human Rights. So this is a part of local law. So this one also is, oh sorry, this is not that. Part of the law. So this article also protects the people private and family life, home and correspondence. So if the government wants to monitor someone, they have to show it's lawful, necessary, and proportionate. So basically that it's really needed and not excessive. So let's move to the Europe Union side. So this is the book referred to that. So, in the European Union, the GDPR or the General Data Protection Regulation, so which takes privacy even further. So, it focuses on consent and transparency. So, under the GDPR, people should know exactly what data is being collected and why it's collected and how long it will be kept. So, that one also is a necessary. If the data is collected, it's okay sometimes, but how long it will be kept? So how many years or how long? So this one is necessary. Maybe it's used after 20 years, so it's different. So that's why. Uh, um, uh, Yeah. Then the other thing is, it's not just about criminal cases, so it affects how compliance handle our information too. So it's other than the compliance, how they use our information. So we need to know how to do everything because it's of ourselves. So if we compare all these systems like Canada, USA, UK, and European Union, they all agree on one thing, which is privacy is an absolute. So, but it's incredibly important. So every country try to balance it with public safety, but they all draw the line in slightly different places. So Canada tends to take a more protective approach, other than the US focuses on reasonableness. Mm, when I compare with the United Kingdom and European Union emphasizes proportionality. Mm, mm, we can say the interesting point in Canada is how privacy changes during an arrest. So if we are arrested, police can search our phone and our belongings. So, but it has to be directly related to the arrest. So, which one is stated from this case? Are we wrong? So from the RP around 2014, so they can check our phone for safety evidence, but they can't go on the fishing expedition. So it should be related to the case. Otherwise, they couldn't try to find any new things from the phone without any warrant for the devices. So in short, across all these countries, this message is same. So privacy is matters. So and especially digital privacy. So and when investigators want to look into someone's personal life, it needs to be justified, authorized, and reasonable. So as technology evolves, so does our idea of what private it's really matter. Okay, let's move to the question number two. Um, so, it I need to talk about privacy in workplace. So, which is honestly one of the most interesting area of digital law right now, especially with remote work and employee monitoring tools becoming So common. So today, most of us use devices that our employees provided, like laptops, phones, or maybe even cloud accounts. Also, it's related to the job. So, but we also use them for personal things. So, if you have any laptop, so maybe its memory is higher than a personal computer. Maybe they will save some documents or data or something like that. If it's anything related to the work or like a personal thing also. Maybe if they need ready to print out anything or anything else, we will save some documents or some files, personal files also in the computer, the uh, work computer. So that's a common thing. Mm, and that's where the question comes in. Do we still have a reasonable expectation of privacy at work or when working from home? So we have to talk about the four different angles. So Canada wise, then the EU and USA and UK. So we have to compare all these four countries with the legal and non-legal side. Let's move to the Canada side. So in Canada, this question was addressed directly in a major case called RV Call. So this is the case, is the Supreme Court judgment. So uh, this is it involved a teacher who used this is the actual story because of the case. So what's happened? So it's a school teacher who used his school issued laptop for personal purposes. So when she has some inappropriate files were found, the school handed the computer over to police. So, but without a warrant. And that's the thing. So the Supreme Court said something really important here because even if an employer owns the device, the employees may still have a reasonable expectation of privacy in its content. So that's the natural thing. So if it's in the simple terms, so the ownership and privacy are the same thing. So the court ruled that the teacher's privacy had been breached because the police needed a warrant. Without the warrant, they seize the device and check everything. So that one is a uh, privacy is breached in there. So that the thing court said. Then the other one is the decision is set a clear standard. So the privacy doesn't disappear just because the device belongs to the our workplace. When you look at the non-legal side, so this is the office of the privacy commissioner. So this is stated here, so you can check it. It's not working. Okay, so no, it's working. So okay, but this Office of the Privacy Commissioner of Canada has also emphasized that employers must balance their right to manage operations with employees' right to dignity and privacy. So, which means that companies can monitor, but only for legitimate reasons. So, things like ensuring productivity, safety, or preventing misconduct. So, and 2023, the Ontario Employment Standards Act also has, here's the link about these Ontario rules. Which is also emphasized that employers which is also sorry which is also request that companies have 25 or more employees so to have a written electronic monitoring policy, so they have to keep a policy about how they monitor about their electronic device. So that's not just a formality, so it ensures the transparency so the employees know what's being tracked. So no conflict in between employers and companies also. So now look at the international wise. So when I look over the European Union, the General Data Protection Regulation, it's called GDPR. It's another layer. So here's the act. Oh. So this 88 the article 88 of GDPR also specifically deals with data processing in the employment context. So it says that any workplace monitoring or data collection must respect human dignity and legitimate business purposes. And European Data Protection Supervisor 2022. It's on legal side. So this one also even warned against excessive monitoring. So especially during remote work. So they noted that things like webcam tracking or keystroke locking can easily cross the line into surveillance. So it's mentioned in here. So let's move to the USA side, United Kingdom side. So here's the case of Babalu in Romania. So here's the final and the judgment of the court on the case. So this case from the European Court of Human Rights, so it's really set the tone. So that case involved an employee who was fired after his employer monitored his work messages. So the court ruled that employers can monitor, but only when it's necessary and proportionate. So when the employee is properly informed beforehand. So following that, the UK Information Commissioner Office, here's the link. So this ICO and ACS also is the advisory, conciliation, and arbitration service. So both released guidance stressing that monitoring should be minimal, and the consultation with employees is best practice. So again, the theme is transparency and proportionality. So employers can watch, but not spy. So here's the cases about that. So these are the, so it stresses the notice that, so they need to inform about that. So what's gonna, these are the non-legal cases. So here also it said how they are monitored and which one are monitored and everything they already stated before everything happened. So let's move to the USA side. So in the United States, things work a little bit differently. It's not similar of Canada. So the Electronic Communication Privacy Act also it's called ECPA, so which is from 1986, allows employers to monitor work systems. So, but usually only with notice or consent. So the idea here is that if an employee knows their communications can be monitored, so they lose the reasonable expectation of privacy. So, but even some scholars like, so here is that. So this is that about the the ECPA, but a scholar like determine in here, they have pointed out that US law still leans more towards protecting employers than uh, employees. So this is the issue in USA mostly. So there's a cultural difference. So the US focuses on company rights and productivity, while Canada and Europe emphasize dignity and fairness. This one also the other case. So this it's covered about it's used reference as non-legal US side. So this one also explore about the employees' consent and communication monitoring. So it's a US is different than the other countries also. So they focuses on companies' rights and productivity, while even the Canada and Europe emphasizes dignity and fairness. So and honestly, that's something a lot of companies struggle with now. That people work from home. Because even though it's your home, the laptop and systems might belong to the employer. So the boundary between work and private life is slightly blurrier than ever. So if we compare the systems, we can see some clear patterns. So in Canada, the courts recognize a limited but real expectation of privacy in the workplace. In the UK and EU, proportionality and consent are the key. So employees should know or they are being monitored. In the US, it's privacy rights at work are weaker, but consent and clear policies still matter. So, what does this mean for investigators and employers? So, it means privacy doesn't just vanish at work. So, companies should have strong policies, notify employees clearly, and use monitoring tools responsibly. So, and employees should understand that personal use on work devices always carries some risk. The Here's the so this one also I added for the Canada side. So this one also in that privacy in the workplace is about balance. So balancing the employer's need to run their business with the employee's right to dignity. So the Office of the Privacy Commissioner of Canada also puts it transparency and fairness are what keep the balance intact. Okay, let's move to the question number 3, which is warrant for computer search. So it's a device, digital device. Looking about Canada. So first one is when does the Crown need a warrant to search a computer? So okay, so let's start with the part A. So when exactly does the government or the Crown need a search warrant to look at someone's computer? So in Canada, we already know about this Canadian Charter of Rights of and Freedom. So this law with protects everyone from unreasonable search and seizure. So this section is basically our digital privacy shield. So it makes sure police and investigators can't just go through someone's private information without any legal authorization, without any warrant. They cannot access any digital devices. So the rule is pretty simple in principle. So, but it gets complicated with technology. So police almost always need a juridically authorized warrant. So to search a suspect's computer or phone. So the main reason is that digital devices are like filing cabinets or glove compartments. So they are incredibly personal. So they can hold pictures, photos, and private messages, and their financial records, and even the health data also, or lab requisition, or any blood work reports, or something more about that. So, in other words, a complete profile of someone's life. If we can say nowadays, we can say the smartphone is similar to that. So, when we look at the good judgment of RVVU, so this Supreme Court judgment has reinforced this idea. So in several key rulings, so one of the biggest one is RV Wood 2013. So in that case, police had a search warrant for a house, but went ahead and examined computers found inside without getting extra permission. So the court said that was unconstitutional. So just because officers can search a house doesn't mean they automatically get to dig through the digital devices inside. So if it's in a house, when they search something else, when they get any devices, they cannot access or dig something in the device. So they need a permission, they need a warrant for that when they do it. So the court emphasized that searching a computer is far more instructive. So investigators need specific authorization in their warrant to do that. So the other case also, this R.V. Reeves, it's happened in 2018. So this is the Supreme Court judgment. So in this case also involved a shared computer between two partners. So one of them consented to police taking it, so but the other didn't. So if he shared with if if it's a shared computer, so if it's one person has an issue or any warrant to arrest or investigation, so what about the other one? If he did it, so his data also will be checked. So the court said, the court ruled that even though one person said yes, the consent didn't raise the other's privacy right. So if it's one person said yes, you can check it, but they have to get the consent about the other person also because it's a shared computer. So that's why. Mm, so police still need a warrant. So together these cases send a really strong message. So in Canada, the police must get the judge approval before searching a computer or phone, unless they are truly urgent reason. So if it's an emergency reason, they need to do that. So which one is protects not just the privacy, but also the fairness and reliability of investigations. So the general rule is no warrant, no search. So when this police skip the step, they risk having their evidence excluded later in court. So which leads us to in the part B. Let's move to the part B. Hi. Yeah. This is the question 3 part B, when the Crown lost cases. So let's look at some examples when the Crown, so meaning the government side, so Crown means the government side, so actually lost in court because investigators didn't follow the rules. So the first major case to know is R.V. Morley 2010. So this is the case. So, in this case, a police got a warrant to search a suspect's home for evidence of child pornography. But when the defense reviewed the warrant, they found some serious problem. So the police affidavit basically the document explaining why they need the search. So was full of inaccuracy and misleading statements. The Supreme Court ruled that the warrant shouldn't have been granted in the first place. So and the search violated section of 8 charter. So which is we earlier talk about the Canadian Charter of Rights of section 8. So which is also we need the warrant before the search and seizure. So because of that, all the evidence from the computer was thrown out. So this case is a reminder that even small procedural errors can destroy a major investigation, because this is a very critical case, because it's a child pornography is not a movable case, so it's a uh, big offense. So they need the proper um, statements to go through with this case, because how they related with the phone, related with the devices, the electronic devices, and the case, because the pictures and videos and everything will be stored in any device. So if they can access the device, if they can seize the device, then they will get the evidence of about this case. So because of these things, this case is destroyed. So it also showed that court's willingness to protect privacy. So even when the charges are serious. And another example is this RV Code 2012. So I used this reference earlier also. So yeah, the same case we discussed earlier for workplace privacy. So here this case also used as reference, because this case the police used evidence that the school board had found on a teacher's laptop. So but they didn't get a warrant before examining it. So the Supreme Court decided that the teacher had a reasonable expectation of privacy in that device, even though it was owned by the employer, the school board. So it contained personal files and browsing data also. So since the police assessed it, so without any judicial authorization, the search is violated, which is Section 8 of Canadian Chartered. So the evidence was excluded. So now both of these cases, this RV Morley and the RV Code, so both these cases went beyond the first trial. So they reached the Supreme Court, showing how serious these privacy issues are. So in uh, Morley and Cole, the Crown argued that the government argued that excluding the evidence would let guilty people go free. So, but the court said charter must comes first, the Canadian Charter of Rights. So, Section 8, that one is comes first. So, if the state breaks its own rules to collect evidence, so that evidence can't be used. So, otherwise, it undermines public trust in the justice system. So in both cases, the takeaway is very clear. So the court prioritizes due process and privacy over convenience. So even in disturbing or high stakes investigations, the government has to respect the charter rights, which is prevent from unreasonable search and seizure. So that's when the government loses cases. So when investigators ignore the need for proper warrants or cut corners that promise privacy. Now let's move to the question number 3, part C. So which is when the Crown won cases. So let's look at the opposite side. the times when the Crown actually won. So even though police didn't have a warrant. So before that, we talk about the Crown losers because they don't have the warrant. So now we're gonna look at the two cases about Crown win, even though they don't have the warrant. So it should be, before I go to the cases, it should be the emergency or the reason of the case. So it's depending on that. So the first big example is RV Fearon. So this is the case file. So this is the case file. So in this case, police arrested a suspect and searched his cell phone without a warrant. So they found incriminating text messages and photos. So the defense argued that this is violated Section 8, but the Supreme Court allowed the evidence. The reason is the major thing because it was considered a search incident to arrest. It's directly related to the this arrest and the device is directly related to the case. So the court said police can, in certain circumstances, so search an arrested person's phone immediately. So if the search is truly related to the reason for the arrest, so like checking for a complete the complaints or evidence that might be destroyed. So some of the cases, if they didn't get the device, they can erase or delete the evidence. So that is not good for the case. That is not good for the case. So that's why they need to seize the device immediately to protect the evidence. So, but they set very strict conditions also. So first one is the phone search must be truly connected to the arrest, so not just curiosity. And the second one is the search must be limited. So for an example, looking only at recent messages, not all the case history about this messages, pictures, and browsing data and everything. Just limited in their access also. And then the officers must take notes describing what they searched and why. So they need to get a document why they need to check these things and what they did that. So everything is need to be set. So this 4UN also didn't create a loophole. So it's just clarified when quick limited search are allowed. And another case, also the RV side. So this one, and this one has happened is 2016. So this case also involved a sexual assault investigation where police collected physical evidence from a suspect's body without a warrant. So the defense said that was unconstitutional, but the court disagreed. So they ruled it was justified because waiting for a warrant would have destroyed crucial evidence. So together, these two cases, the Fieron and the Said, so both are shows that the courts recognize the real world challenge as investigators face. So especially when time is critical in many cases. So the charter doesn't mean paralyze police work. So, but to make sure it's reasonable, proportionate, and respectful of rights. So we need to, because of the charter of rights, also protect the unreasonable search and seizures. But the if it's necessary of that time, we need to do so. It's depending on the case. So, uh, what's the interesting is how these cases draw the line between flexibility and abuse. The government can win when officers act responsibly in urgent situations. So, but not when they ignore the system altogether. So from investigators' point of view, this means documentation and justification are everything. So if you search without a warrant, we must be ready to explain why it was necessary and how it was limited. So that's what make the difference between lawful exception and rights violation. In summary, so in this question 3 summary, in part A told us that warrants are the rule. And part B showed that when police skip the rule, evidence can be thrown out. And then the part 3 proved that in rare urgent cases, courts might accept warrantless searches. So, but only if they are reasonable and properly documented. So all of this reminds us in Canada, digital searches must balance two powerful values. First, the need to investigate crime and the right of every person to privacy. And the technology keeps evolving. So that balances will only get more complicated. Okay, let's move to the next question. So my student, so the question number 4 is illegally obtained evidence. So the country is depending of my student ID, which is 100671097. So the ending digit is 7. So my country is New Zealand. So this part is divided by legal and non-legal. So yeah. Uh, Now let's talk about what happens when police break the rules. So when evidence is gathered illegally or improperly. So this is the one of the most fascinating areas in privacy and forensic law because it tests how far justice can go before it stops being fair. So it's regarding with the country of New Zealand. So New Zealand also this is covered mainly by Section 30 of the Evidence Act 2016. Here's the link of that. So we can go through it, which one we want. So we can check everything about this law in New Zealand. So now this section 30 doesn't give a simple yes or no answer about using improperly obtained evidence. Instead, it tells judges to weigh everything and apply a balancing test. So basically, the judge asks, would admitting this evidence make the trial unfair, or would it damage public confidence in the justice system? So it's not that every technical mistake means that evidence is thrown out. So it's dependent on how serious the breach was and whether the police acted in bad faith. So one of the key cases that led to Section 30's wording. So in RV Shahid 2022, here is the link. This is the case of that. So in that case, police took a blood sample without getting proper consent. So the court ruled that even though the evidence proved guilt, the way it was collected is violated the person's rights so severely. So that is couldn't be allowed. Without consent, collected their blood. So it's biometric thing. So without consent, without warrant, so they collected that. So this case really sets the tone. So it showed that in New Zealand, so the ends do not justify the means. So you cannot violate someone's rights just to get conviction. Later on, that Evidence Act 2006. So we looked earlier here, this act. So basically wrote that idea into law. So it tells judges to balance the seriousness of the rights breach against the importance of the evidence. So after a few years later came another huge case, which is Ham. So I couldn't get sorry, here's that. Here's the link of the case. So here the police were investigating a group of activists and secretly installed video cameras on private property without a warrant. So the Supreme Court ruled that this kind of covert surveillance was unlawful because it seriously invaded people's privacy. So in the private property, when they fix the camera, so it will take all the videos. So if who is coming inside or who is going outside, what they are doing in the house or in the place and everything. So this one should be breached their privacy. So most of the video evidence was excluded. So even though it was very relevant to the case, so because of the breach of the privacy. So that decision was a major wake-up call for law enforcement. So it reminded them that technology can't be used to sidestep the law. So just because something is possible doesn't mean it's illegal. So but not every case goes that way. So there are some cases, there are some situations where the courts still allow improperly obtained evidence. So especially when the breach was minor or accidental. So here's the good example of that. R.V. Williams. So here is the judgment of that case. So in this case, the police made a small procedural mistake, but the evidence they found was crucial to proving the serious crime. So the court decided to allow it, saying that excluding it would harm justice more than help it. So it's depend on how important this evidence for this case and how harm of this case, how serious of this crime. So the pattern we see in that New Zealand courts take a very balanced and practical approach. So they are not out to punish police for every slip up. So, but they also won't let rights be trampled. So now if we look at what's been happening outside of the courtroom. So at the New Zealand Law Commission, here is the link. First of all, we will look at so in here they did a major review in 2019. They looked at how Section 30. We already talked about this Evidence Act 2006 Section 30. So had been working and found that. So overall, it strikes a good balance. So, but they also said investigators could benefit from more training in privacy law and warrant procedures. So, especially in digital investigations where lines can blur quickly. So, and the New Zealand's police manual in 2021. So just we can read only. Here's that. So which one? This one also supports that. So it now emphasizes the principles of necessity, proportionality, and documentation. In simple terms, don't collect evidence unless it's really needed. So use the least intrusive method possible and always record what you are doing and why you are doing that. Documentation is very important in New Zealand and in Canada also. So for digital forensics and privacy investigations, these rules are huge. Let's say you analyzing a suspect's computer and when you discover evidence from a location or file that wasn't included in the warrant. So if you access that data anyway, even by mistake, the defense could argue that it was an illegal search. So, and all your evidence could be excluded. So, investigators must be careful not just to find the truth, but to find it the right way. They need to prepare and document it, everything. So this approach also builds public trust. So people are more willing to cooperate with investigations when they believe police follow the fair procedures. So when evidence is collected lawfully, convictions are stronger and more respected. So when it's not, the whole system can lose the credibility. So it's also worth comparing this to other countries. So like Canada. So in Canada, under Section 24 to this one also it's the Canadian Charter of Rights. So which is courts includes evidence obtained in a way that would bring the administration of justice into repute. So in New Zealand's version just gives judges a bit more flexibility to consider the specific circumstances. So when I sum up this, so this R.V. Shahid and Hamad and Williams and all these, then R.V. Shahid cases is this RV cases is created the balancing test, and the Hamad cases reinforced privacy rights in the age of surveillance. And the last one is Williams also showed that sometimes if the breach is small and the evidence is crucial, it can be still admitted. And the both Law Commission and the Police Manual also remind investigators to act with care, transparency, and fairness. So the big takeaway is that in New Zealand, justice isn't just about getting convictions. It's about protecting rights, even when it's inconvenient. So that's what keeps the system fair and legitimate. So especially in the digital age. Yeah, let's move to the next question, question number 5, which is exigent circumstances in Canada. All right, so let's talk about extinction circumstances. So basically, those rare situations where police can act without a warrant because there's yes, just no time to get one. It's limited time. So in Canada, this exceptions comes from a section of 487.11 of the Criminal Code. So, and it's also shaped by Section 8 of Canadian Charter of Rights and Freedoms. We already talked about this Canadian Charter of Rights and Freedoms. So this is the other section, Section 8. So the idea is that sometimes waiting for a judge's approval could mean losing vital evidence. So or even risking someone's life. So the law gives officers a little bit of flexibility, but only in truly urgent situations, not all the time. Uh, Now the key word is urgent, emergency. So it doesn't mean convenient. So the Supreme Court has made that very clear. So if it's very emergency situation, they can't do that. Otherwise, it's not. So when I look at this case, RV Petron, Supreme Court judgment case. So this one also, the police entered a man's apartment without a warrant after smelling marijuana. So the drugs. So the court ruled the entry unconstitutional because there was no real emergency. So they said exigent circumstances only apply when there's an imminent risk, so immediate and very emergency, very urgent situation. So, like physical harm, the destruction of evidence, or danger to the public. So, suspicion alone isn't enough. So, when you have suspicious about that, it's not enough. It should be an urgent condition. And another case of McDonald. And this is another big case. So R.V. McDonald, which has happened 2014. So the story is here an officer approached a man's apartment because he thought the man had a gun. He thought, but you don't know it's real or not. So when the door opened, the officer saw the weapon and entered without a warrant. So and the Supreme Court upheld that action, so saying that protecting public safety can justify immediate entry because they saw the weapon when they opened the door. So, but again, it has to be necessary and proportional. They got the gun. If it's not, this one is the privacy breach. So they saw the weapon when they opened the door. So even if even they suspect that uh, they don't have the warrant, so even though it's accepted from the court. So the courts are saying you can break the normal rules, but only when waiting for a warrant would be irresponsible or dangerous. For digital investigations, so the principle still applies. Like if there is a risk that crucial data is about to be deleted remotely, or someone's life could be endangered if investigation delayed. So, but these are exceptions, not excuses. We had to clarify them. So, in practice, police and forensics teams need to document everything carefully, what they did, why it was urgent, and how they limited their search to only what was necessary. So, because if the situation turns out not to have been truly exigent, the evidence might still get thrown out later under Section 8 of Canadian Charter of Privacy. So, in summary, exigent circumstances give police limited authority to act fast, but it's a narrow doorway, not a shortcut. So, the moment the emergency ends, the normal warrant rules kick back in. That balance between urgency and rights, so which is keeps our system fair even in high pressure moments also. Let's move to the next question. Question number 6. It's privileged information on computers. Yeah, and this one's about privileged information, so which means the kind of data that's legally protected from disclosure, especially in a lawyer-client relationship. So this type of information is one of the most private things that can exist in the justice system. So it's not just about confidentiality, it's about protecting the fairness of the whole legal process. If a client can't trust their lawyer to keep things private, the justice system simply can't work. So in Canada, this protection comes from both case law and the Charter of Rights and Freedoms. We already talked about this Charter of Rights and Freedoms. So this is protected by these tools. So the key decisions here's the case, so we can look at. Mm, the key decisions here, that is correct, we 1982 and this Lovely 2002. This is another case. In this first one, the Supreme Court said solicitor client. So this is regarding with the solicitor and the client. So privilege is the fundamental civil and legal right. So it means that government must avoid any unnecessary intrusion into communications between lawyers and their clients. So and the next one, this lovely. So the court went even further, saying that if the state seizes a lawyer's file, those materials must be sealed and reviewed by an independent party before anyone looks at them. So the lawyer should be have lots of clients and their case details and more personal and privacy things. So if the if this is the files, they need to, it's they don't have enough rights to go through them immediately. So they need to wait for the procedures. So this was later reaffirmed in Canada Attorney. So here is that. For Canada Attorney General V and Federation of Law Societies of Canada. Here is the article here about it. So this one also, the court ruled that solicitor-client privilege isn't just a legal technicality. So it's part of the constitutional rights to a fair trial. So what does that mean in a digital context? So it means that if investigators seize the computer or any digital device and it might contain privileged files, say a lawyer's email, achieve or digital case notes, so they can't just open everything. So they have to protect those files the same way they would protect sealed and envelopes. So typically, an independent counsel or court-appointed reviewer goes through the data to make sure only non-privileged information is handed over to the investigators, not all of them. So in practical terms, this rule matters a lot for forensic examiners. They have to use strict search protocols. So sometimes with special filters or clean teams to avoid accidentally exposing privileged materials. So the main takeaway is very simple. So privileged information on a computer is off limits unless the court says otherwise. It's a reminder that even in digital investigations, privacy and due process go hand in hand. Okay, let's move to the question number 7, which is Cloud Act versus MLAT, Canada and US. We will talk about this both these two countries. So now let's talk about cross-border data and how it's shared between these countries. So specifically comparing the Cloud Act in the United States and the MLAT process, which is uses in Canada. So this topic has become a big deal because crimes today are often digital. So data stored in a cloud, usually everyone using that. So sometimes in a completely different country. So how do investigators get access to legally? So if it's different country, so if it's the suspect is in another country, the cloud computing can be used in a different, so what they deal with that. So how do investigators get access it legally and without overstepping privacy or sovereignty, because it's a different country, because it's different country, different laws and regulations are using. So what they can do that. So first of all, we will start with the Cloud Act. So here's the, sorry, here's the link that. This is the Cloud Act, so which stands for Clarifying Lawful Overseas Use of Data Act. So it was passed in 2018 in the US after a major case, the Microsoft Island case. Here's the case. After this, it's happened. So, yeah. So, in that case, US authorities tried to force Microsoft to hand over data stored on a server in Ireland. So, Microsoft refused, saying American warrants shouldn't apply overseas. So thereafter, the Cloud Act was Congress's response to that. So it basically says that US tech companies must provide data to US law enforcement, even if the data is stored abroad. So as long as it's under their control. So it also lets the US make executive agreements with other countries so that they can request data directly from each other. So without going through a long diplomatic process. Now that sounds efficient, but it raises major privacy and sovereignty concerns. For an example, what happens if Canadian citizens' data is stored by a US company like Google or Meta? Could American authorities access it without Canadian oversight? That's where the MLAT, or it's called Mutual Legal Assistance Treaty, comes in. So Canada uses these MLATs to request or share evidence with other countries in criminal cases. So yes, that with this Canada using. Under the system, a Canadian investigator can ask the Department of Justice to send a formal request to the other country's legal system. So then the country's courts reviews the request, and if it's appropriate, order the data to be handed over. So the MLAT process is definitely slower. So because it request to get the request, then the code should be approved after it's investigate it's needed or not. So sometimes it takes weeks or even months because of the process. So but it includes strong judicial oversight and respects each nation's laws and privacy protections. So the Office of the Privacy Commissioner of Canada, so here's that. Which has also raised some real concerns about the Cloud Act. So they warned that if Canada entered an executive agreement with the US under that act, it might allow foreign access to Canadians' private information without going through Canadian courts. So that could conflict with Section 8 of the Charter of Rights and Freedoms. We already talked about that section, so which protects against unreasonable search and seizure. We use this reference most of the time in this course. And in contrast, MLATs through slower keep the system fair. So they ensure that both countries follow due process. So it's difference between efficiency and accountability. From a digital forensic point of view, this matters because investigators must know where their data requests are going and whether the privacy laws in that country protect the evidence they are after. So, a mistake in process can lead to evidence being rejected in the court. So the wrap up of this question, the Cloud Act prioritizes speed and access, but risks privacy and sovereignty. But the MLT system prioritizes due process and mutual respects between nations through its slower. And the challenge for Canada is finding the right balance. So cooperating with allies like US while still upholding Canadian privacy rights. It's a great example of how technology has outpaced law and why legal systems everywhere are still catching up. Yeah, let's move on to question number 8. So, which is privacy principles beyond Canadian stand. So, for this question, we need to talk about privacy principles, specifically how the rest of the world goes beyond Canada's 10 fair information principle under PIPEDA. So, the Personal Information Protection and Electronic Documents Act. Now, these 10 principles, things like consent, accountability, and limiting use, are great. They are guided Canadian privacy law for over 2 decades. So, but around the world, privacy laws have evolved, especially with the rise of social media, data analytics, and artificial intelligence. Other regions, especially Europe, have added new ideas that give individual more control over their data, not just protection. The most famous example, of course, is the European Union's General Data Protection Regulation. It's called EDPR. So here's that. So this is the article about the data protection. So uh, which came into force 2018. So the GDPR builds on principles similar to Canada's, but it adds a few new ones that really stand out other than the Canada's rules. So one of them is the right to be forgotten. So found in Article 17. Here is the Article 17. So this gives individuals the right to ask organizations to delete their personal information when it's no longer needed or when consent is withdrawn. So that's a big deal. Yeah, compared to the US and Canada. So because under Canada's PIPEDA, we won't have an explicit delete my data right. So companies must stop using data once the purpose is complete. But individuals who don't have the same power to demand erase them. So it's depend on the company. If they collect it, that's it. So and the another major addition under the GDPR is data portability. So which one also is found in the Article 20, data portability. So this allows people to request their personal information in a structured, common digital format and transfer it to another service. So for an example, switching from one social media platform to another without losing all the personal history. So again, Canada doesn't yet have a clear equivalent of this. So this principle gives users ownership, like control over their data. So there is also privacy by design. Which became a core concept in the GDPR. So, and uh, interestingly, it was actually developed in Canada by Ontario's former privacy commissioner, Dr. Anne Joaquin. So, which just means that privacy protection shouldn't be an afterthought. So, it should be built into systems and processes from the very beginning. So, now I'll go to the outside of the Europe, the Asia Pacific Economic Cooperation, the APEC. So, this is the link. This is the article about it. This is the book. So, when you go through this book, it's that. So, and this one also is a region has its own framework, the Tech Privacy Framework 2005. So, which is focuses on accountability and encourages businesses to take responsibility for personal data, even when it crosses borders. So, and the other one is OECD privacy guidelines. So this one also last updated in 2013. And another key element enforcers. So they stress that privacy rules must be backed by strong oversight bodies, so not just policies on paper. So if we compare these global principles with Canada's, the big difference is empowerment. So Canada's PIPEDA principles focus on protecting data through proper handling, while the GDPR and other global frameworks focus on empowering people to control what happens to their information. So they have the rights of their data, not the company or investigator or other things. They have the most rights of their data. Mm. So what does this means for the future? So it means Canada will likely need to modernize the PIPEDA. So in fact, Bill C-27, which would create the Consumer Private Protection Act, the CPPA. So it's meant to align Canadian law more closely with the GDPR. So that includes stronger penalties, more transparency, and better individual rights. Uh, when I sum up with the question number 8, so the Canada's 10 principles form a strong base, and the GDPR builds on them by giving users control through rights like erasure and portability. And APEC and OECD frameworks emphasize accountability and enforcement. So, and together, they show that privacy isn't just about data security. It's about giving individuals real power over their digital lives. Okay, let's move to the last question, which is the privacy report. So, question number 9, privacy report. So, this question, I reviewed investigation report of number 521131 from the Information and Privacy Commissioner of Ontario. So, here is the link of the case. It is also given in the statement. In this case, focused on a program called the Children and Youth Family Information Portal, or CYFIP for short. So it's a digital portal that stores and manages sensitive personal and health information about children and their families who receive social or medical support. So it's like minority people kind of. So the incident that triggered the investigation happened when staff members accidentally sent personal health information, including names, dates of birth, and case details. So through an unencrypted email. So that mistake caused a privacy breach under Ontario's Personal Health Information Protection Act, the PIPEDA, the PIPA. Here's the rule. So they breach this rule when they send the personal data without encrypted email. Now, PAS sets strict rules on how health data can be used and shared in Ontario. So it requires health information custodians like hospitals or social services or take reasonable steps to protect data and prevent unauthorized access or disclosure. In this case, the organization had some security measures in place, but the IPC found that they weren't strong enough, especially for handling electronic communications. The investigations revealed that staff weren't properly trained on secure emailing practices, and that the organization didn't have adequate encryption or audit controls. So, even though the breach wasn't intentional or malicious, so it showed gaps in data protection and oversight. The IPC also concluded that the organization failed to meet its obligations under PIPA, specifically under sections dealing with administrative and technical safeguards. So they issued several recommendations, including um, implementing mandatory encryption for all external emails containing personal health information, and then providing regular privacy and security training for employees, which is necessary how they can handle these kind of sensitive data, and creating stronger internal policies on incident response. If it's anything happen, how can they deal that? What's important is that the IPC didn't just criticize, they guided the organization to improve. The report emphasized accountability and learning from mistakes rather than punishment. Mm, so, in simple terms, this case wasn't about a big cyber attack or hacker. It was about human error, like weak procedure, and the real world consequences of failing to secure digital information. So, this is a great example of how privacy breaches often happen not because of technology, so but because of people and processes. So, and that's what makes this investigation so valuable. It highlights that privacy compliance is as much about culture as it is about software. Let's move to the part B, discussion and connection to our course topics. Was the question. So now let's connect this report to what we have studied from this course in class. So privacy, we learn about privacy, search, evidence, and computer, the electronic device security also. First, in terms of privacy, the report shows exactly what happens when the basic principles of confidentiality and accountability break down. The PIPA is meant to safeguard personal health information, which is one of the most sensitive kinds of data. When the trust is breached, even unintentionally, it can seriously harm people's confidence in public institutions. Then the second one is from a search and evidence perspective. So this report also connects with Canadian case law, especially this RV. Where is that? So in this case, the RV Cole case, another one is the Spencer 2014. And both of these cases deal with expectations of privacy in digital context. So in Cole, this first one, the court said that even when data stored on an employer on device, we already talked about this in the workplace privacy. So the courts there is still a reasonable expectation of privacy. And the other one is Spencer also, the court emphasized that information held by third parties like internet service providers still deserves constitutional protection. So now if we apply those ideas here, so we can see the same reasoning. Families who use CYFIP, this trusted that their data would be handled securely. So the organization became a kind of custodian, just like an ISP or employer in those cases. So when the data was mishandled, it wasn't just a technical mistake, it was a privacy violation with legal consequences. On the computer security side, the last one, the report reflects some of the basic cybersecurity principles we have discussed, especially encryption, authentication, and staff awareness. Even with strong systems, human error remains the biggest risk factor. That's why security experts often say the weakest link is the human link. It also relates to the broader theme of digital evidence of integrity. So, just like forensic investigators have to document every step when collecting or examining evidence, organizations have to document how they handle the personal data. So, that's what ensures both transparency and accountability. And finally, also from a policy standpoint, so this case demonstrates the importance of preventive design, something like the privacy by design. So, framework developed by Ontario's own doctor. So we talked about this one earlier. So it means building privacy protections into everyday systems. So not treating them as afterthoughts. So, in short, this case brings together everything we have learned. So, legal frameworks, technological safeguards, and ethical responsibility also. So, it is a real world reminder that protecting privacy isn't just about obeying the law, it's about earning the trust from the public and the people. Yeah. Now I'm in the end of the part C, my critic and personal view of this question 9. So mm, now for my own critic of this report and whether I agree with the IPC's findings and recommendations. And overall, I do agree with the IPC's approach. I think they struck the right balance between accountability and education. The breach was caused by negligence, not malicious intent. So, focusing on better training to the staff and clearer procedures makes sense and protect and prevent this will happen again. Punishment alone wouldn't solve the root of the problem. So that said, I think there's still room for improvement. So, for an example, the IPC could have required mandatory follow-up audits to make sure the organization actually implemented those recommendations. And it's one thing to create new policies, so but it's another to confirm they are working 6 months later. So also the case highlights how reactive many organizations still are about privacy. So they tend to fix things after a breach happens. So in my view, privacy protection should be proactive. So through continuous staff education, regular risk assessment, and clear accountability structures. From the legal perspectives, this report connects nicely with the reasoning with these two, this R.V. Cole and R.V. Spencer. So, which both affirmed that digital data deserves strong privacy protection. Even though the CYFIP breach wasn't criminal investigation, the same logic applies here also. people have a reasonable expectation that their sensitive information will stay private unless there's a lawful reason to access it. So one thing I really like about the IPC stone, so which is that it's constructive. So instead of just blaming, it focuses on improvement. So that's important because many privacy breaches come from overworked staff or unclear policies, not about the bad people or staff. So, but I would go a step further and suggest that Ontario health and social service organizations adapt a technical safeguards similar to those in the federal GDPR. This is very advanced than Canadian rules. So, like encryption by default and periodic privacy impact assessment. So, these proactive steps could prevent exactly this kind of breach from happening again. So, to conclude that, I would say this report perfectly illustrates how the smallest mistake in handling data can have huge con- consequences. So, it reminds both public institutions and private organizations that privacy isn't just a compliance checkbox, it's a shared responsibility. And it ties together everything we have talked about in this course, from search and Caesar law to digital evidence, forensic ethics, and privacy by design. Hope I answered all these questions with the references. Thank you. Mm, I think one or two of the reference it's not open. It says 404 page. I will add it up in the list also, or maybe in the later of the video I will add these things. Thank you.